So welcome to this month's Lunch and Learn. Today we're focusing on optimizing your patent strategy. Really excited to welcome Sheline from Echo Health Ventures and Dylan Adams from Wright, Tremaine. Thank you.
Well, hey, Dylan.
Hey.
So thank you, Jessica. Appreciate the intro. So maybe I thought as a way to start out, Dylan, maybe you can just give us your background, what you do for work, and why you're here.
Yeah, so I'm Dylan Adams. Thanks for the introduction. I work at the firm of Wright, Tremaine. I'm a patent attorney. So I would say 98% of what I do is patent prosecution, which is the process of drafting patent applications, filing them at the USPTO, and then working through the examination process. So patent portfolio strategy, and then a bit of litigation enforcement, licensing, things like that. So being a patent attorney, I have to know the inventions as well, if not better than the inventor. So I have my technical background, undergrad in biochemistry and molecular biology, master's in electrical engineering. So I do a little bit of everything when it comes to technology.
And so how long have you been at DWT doing this stuff?
I've been at DWT for 3 years now, but been practicing as a patent attorney for coming up on 15 years.
Okay, wow. Okay, so an expert. We have an expert in the building. And then I guess just to set a couple ground rules, feel free to ask questions as things come up. I obviously have a nice list here that I created. I would say this is also selfishly a list that I'm interested in because as a person at Echo, we think about this a lot around either existing portfolio companies and how do they best protect their IP and build an IP estate, but then also when we're looking at new investments, we look at what companies have done from this perspective, and I think there are some best practices that hopefully we'll get from you out of this time. But maybe we just start with basics. What is protectable intellectual property? I know there are different buckets. I think patents are one bucket. But can you just start there? What is IP?
Yeah, so IP, when people talk about IP, they're talking about patents, trademarks, copyrights, and trade secrets. Patents is one of the four pillars of intellectual property, if you will. So to kind of think about where patents fit in, patents are sort of opposed to copyrights, and the patents protect useful articles. Useful processes, useful inventions, whereas copyrights protect artistic inventions. This is not to say that there's not any overlap. A good example would be, say, like chairs, for instance. A chair is a useful article. You have to protect that with a design patent. But the fabric, if you have a unique fabric design, that would be by copyright. So there's a lot of overlap in those types of intellectual property.
And so, why should we care about patents?
Yeah, so the core of patents is being able to exclude others, right? Being able to exclude others from making, using, selling, offering to sell the patent technology within the United States or whatever jurisdiction you have patents in. But aside from just that ability, that actually ends up being kind of the last thing that people are interested in. Patents allow you to license that technology. You can sell the patents. You can actually use them as collateral and get loans. But there's also the benefit marketing-wise. If you have patented or patent-pending technology, people see that as being something special. It's also helpful for attracting investors, of course, because they see potential in that, but also other collaborators, whether they be potential employees, but also any collaborator is going to be see it as an innovative company if they have a patent portfolio. But also sort of the passive defensive. If you have patent pending technology, a lot of times other companies aren't going to know what's patented and what's not. It's going to deter people from wanting to get into the market because it makes it muddy and makes it more difficult.
So on that front, and this is a question that is near and dear to my heart, and probably near and dear to the audience heart. I've heard multiple different opinions on this, so I want to ask the expert. Is software patentable?
Yeah, so it's a great question, and it's something that people get wrong all the time. So the answer I tell people is no, but yes, and let me kind of explain what I mean by that. So if you try to claim a piece of software that does X, Y, Z, totally not patentable. But what you can patent is a computer implemented method of doing X, Y, and Z, a computer system that performs the steps of X, Y, Z, a computable readable medium that performs the steps of X, Y, and Z. So while the law technically does not allow software to be patentable, it's effectively patentable through other means. I mean, this is what I do day in, day out is patenting software. The problem with some attorneys is they sort of use the technical, well, you know, the law says you cannot patent software, and it sends the wrong message. What people are really asking is, hey, is my software-based invention patentable? Most likely, yes. You know, it's certainly the kind of thing that can be patented.
And I think that nuance or messaging, I think brings up another question around, broader question, what is patentable, right? And I think you're describing basically what I view as like a business process that is enabled by software. That is a patentable idea. Is that accurate?
The business side of things is more difficult. The law has changed so that the business processes, like the way you're doing business, that's not going to be patentable very easily. But the way that software runs, the way that your users interact with the server, the way data is passed around and processed, those sort of things, that's the core of what's going to be patentable, at least in software.
Okay.
Yeah.
Okay. So I guess maybe not a business process, but a service,
yes,
or a process more generally of
yeah,
getting to an end.
Yeah, and
that is a patentable idea.
Yeah, totally. And maybe I'm making that same mistake that I said where, people say, oh, software is not patentable, even though it effectively is. Yeah. Business methods are effectively patentable, but it's done so through the way the interactions occur, on a computer with users, the way data is processed.
Yep.
Yeah.
And then just some other jargon that I've heard thrown around. Wanted to get your definition on it. So I've heard entrepreneurs say things like, this is my crown jewel patent. I've heard other things, design around, fence, portfolio enhancing patents. Yep. Can you explain that to me?
Sure.
All those different types of patents.
So for crown jewel, I would take that to be, that's going to be a patent that the company sees as being really important, that's directed to their core technology, and it may be one that is a really broad patent. So one thing to think about patents, it's not just a binary thing. It's not just I have a patent or I don't. The question really is, do I have a really broad patent that covers a lot of different variations, or do I have one that is so narrow that it would be impossible for somebody to ever infringe, or it'd be really easy to design around, which is kind of another one of the things. So the crown jewel patent would be something that it's core technology and possibly something that is really broad and that covers a lot of different things, and where other patents maybe are more peripheral and less important.
So you got crown jewel and design around. What's fence? How's that different from some of these others?
Yeah, so a good way to think about patents is to really think of it as a fence. It's not really just, I have a patent on my technology, that's it. It's better to think of it as like a picket fence type of strategy. Because different patents can be used for different things, and you want to have broad coverage so that regardless of what competitors come and do, you're still going to be covered. Because again, it's not about, hey, I just want to have my commercial embodiment covered. It's about, I want to have a lot of different variations so that people can't come in and make small little changes to it and design around. And also, you want to be able to pivot your company, change the product, adapt, and still be able to have that covered. And if the patents are so narrow on one embodiment and then you change and then it's not covered anymore, that kind of makes it worthless. So the thing to do is to actually have a lot of patents. And that sounds kind of scary in some ways because it's like, well, tons of patents equals lots of money, but there are cost-effective ways to file multiple patent applications that cost incrementally more than just a single one. I won't get into the details, but it's called continuation applications, where with one application you can get different coverage of different things. You can get broader or more narrow coverage,
that's a good way to have that picket fence strategy, and something that's especially good for startups in the beginning, to set it up so that you can expand the portfolio to do that, but in the beginning be cost effective and just have a single application.
Yeah.
Yes. Yeah, so just to, I guess, to maybe give you like a general example. I mean, obviously it depends on the application, the technology, complexity, et cetera. So let's say a single non-provisional application costs $10,000. If you were to then want to split that into two, you just need to draft a new set of claims, which say would cost $3,000 plus filing fee, so maybe $4,000 for a whole new application, maybe $3,000 to $4,000. Be even cheaper if you were to split it again, right? So you could probably say, you know, for $20,000, that's not going to get you just two. You could maybe get 4 applications that are going to be different. And there can be a lot of benefit that, you know, for a lot of investors or a lot of other folks, they see 4 as 4 times more valuable compared to just one patent application. So you can use splitting applications selectively to build a larger portfolio, and it doesn't necessarily have to be more expensive. There can be different ways to do it. So for instance, in one application, you could have a lot of different variations, right? And that's ideally what you want to talk about. You don't want to just talk about your one commercial embodiment. You want to say, well, okay, what are competitors are going to do? You know, let's cover that. Let's talk about those sort of things. What am I going to do in 5 years when technology is faster, when technology is cheaper, when we have investment and we can do more things? You know, in 10 years, in 15 years, thinking out that far is really good to do. And so you can cover the current embodiments, you can cover what competitors are doing, and then assuming the patent family is alive, let's say a competitor comes out. If what the competitor is doing is covered in what you have described in the specification and drawings, you can have the product sitting on your desk and draft claims right to it, right? So that's one of the benefits of being able to split things off.
You're actually jumping into the next section of the talk.
Sorry to speed ahead.
Which, totally fine. But I think want to spend some time talking about patent strategy more broadly, and knowing kind of the audience is full of entrepreneurs, investors, others. What kinds of considerations do you think need to be made? And you've alluded to a few of them, kind of this idea of broad versus narrow, provisional versus non. I have a few others. Foreign patent protection is another example. What kind of advice do you have? And this is also probably related to the strategy that you elect to employ. So for those that don't know, I think there are a few other jargony strategies, right? There's the sword strategy, which offensive, shield, defensive, a marketing type strategy. I'm going to launch you off into a long discussion here, but lots to unpack there. What do you recommend based off of those different strategies, and what kind of levers do you pull from each of those?
Yeah, so I guess maybe step back a second and kind of talk about the options of starting the patent process, and maybe just sort of about the patent process in general. So there are 2 ways to start the patent process. You can file what's called a provisional patent application, or you can file what's called a non-provisional application. The non-provisional application is the one that is actually examined by the PTO. You file it. It takes about 1 to 3 years before it's picked up for examination at the USPTO. There's a negotiation with the patent examiner where you go back and forth. And you know, the negotiation is in how broad or narrow are the claims going to be, and are those claims new and non-obvious compared to prior art that's out there. Hopefully the negotiation goes well and you get an issued patent. You can start with the non-provisional. However, for startups, I typically recommend starting with a provisional patent application. Okay, so a provisional patent application, it's a placeholder. It lasts just 1 year, and then you have to file the non-provisional at the end of that year to maintain the priority date of that provisional application. Provisional applications are great for startups for several reasons. One is that you can scale them as far as the cost goes. Ideally, they should be as good of quality as a non-provisional application. That being, it fully describes the technology. It should be drafted by an attorney so that you have the right coverage, talk about things in the right way. So it ends up being really broad, so that you have the option to split it into continuations down the road. so it's going to be, you know, fully enforceable, things like that. But if for startups that are, you know, undercapitalized or don't have a lot of money to spend on patents initially, there are options for doing applicant drafted provisional applications, because really the USPTO is going to accept any document you file as a provisional application. So it's a question of, you know, how much protection do you want and how much patent budget you have up front. So provisional can be really tuned to be able to be on the low cost end. Aside from that, they provide a lot of flexibility. So what I mean, as you know, being in startups, products can change a lot, right? So you file your patent application, and that's typically when you're going to start talking to customers, maybe start selling, start talking to investors, and the product may completely change within that year. So it's really easy to adapt to those changes with a provisional application. So within that year, you could file an updated provisional application that talks about the new stuff that you're doing. Or at the end of the year, when you file the non-provisional, you can add those changes then. It's really difficult, or I should say it's not very cost effective to do that with the non-provisional application. You file it, you would have to file a full new non-provisional application. So that's, I would say, my number one strategy is startups should file provisional applications. That's a great way to start. It's cost effective, gives you a lot of flexibility, and allows you then to cover a lot more subject matter as the business changes.
How about prior art searching? And I've heard this termed like competitor studies or market studies of what's already out there. When is that something you would recommend doing? It sounds expensive.
Yeah. So as far as doing market analysis, I mean, as you know, that's essential to, you know, to having a business. You need to know where you fit in, you know, where you're new, where you're competitive. But on the patent side of things, for a lot of companies, it doesn't make sense to do a patent or prior art search. And what that is where you'll look at, say, the patent literature, or you'll look at any sort of you know, technical documents or blog posts or existing products. All of that is going to be prior art. So when the patent examiner at the non-provisional stage is doing the examination, the examiner does a prior art search, and usually that's going to be patent documents, whether that's issued patents or pending applications that have been published, and we'll make a determination: is your claimed invention, as you have it, is it new and non-obvious compared to that prior art? And so doing a prior art search or a patent search will supposedly give you an idea whether or not the patent application is going to survive examination. But realistically, like I said, it's not a binary thing. It's not I have a patent or I don't. It's a question of how broad or narrow is it. And for it's like especially computer type of technologies, it's really hard to do a good patent search or prior art search. The information you get a lot of times ends up being fairly worthless. The best answer you get is, well, you know, probably it's patentable. You know, we don't know. By default, patent applications are held in secret for 18 months at the PTO, so you have a huge blind spot as far as what prior art you know, is actually out there. I usually recommend, depending on the product, there are like maybe small mechanical products or small consumer products where it's easy to determine what, you know, what it actually is and do a search. I usually say don't do a prior art search. It's a waste of money. It can be several $1,000s, and that really should go into filing your patent application. Because again, you know, it's going to be a question of, you know, how broad or narrow the patent is, and it's really subjective when it comes to one examiner versus another. One examiner is going to think that certain prior art is really relevant. Others going to think that other stuff is really relevant. So it ends up being a waste of time to do prior art searches, and I know that that makes people uncomfortable. They want to say, well, I want to know, but the patent process is unpredictable, unfortunately.
That's interesting. How about foreign patent protection?
Yeah, so foreign patent protection, for startups, it can be really dangerous. I've seen a lot of startups where they invest in foreign protection, they file in a bunch of countries, and it ends up being a huge capital suck. And I've seen companies I would argue they went under partially because they were way too invested in foreign assets, and nobody wanted to say, well, we'll let this go, and you know, nobody wants to be the person who says pull the plug on these foreign assets. So be really, really careful if you're thinking about doing foreign patent applications. They're absurdly expensive as far as getting them filed, working them through examination, but then enforcement is typically really expensive and difficult. But there are ways to sort of provisionally capture foreign rights. So I talked about the provisional, and then you file the non-provisional. At the same time you file the non-provisional, you can file what's called a PCT application, which is kind of like a provisional foreign patent application. That gives you another 18 months to decide if you want to go into foreign countries. That's a good option, especially if you are talking to investors or if you know that there are folks in foreign countries you may want to partner with. Then you've at least preserved rights. Those applications typically cost around like $3,500, so it's not super cheap, but it's a good way to preserve things. But doing the actual foreign patent applications yourself, I don't know. I'm really hesitant to recommend those for startups. I mean, unless they have established markets, established business partners, or maybe if their investors really, really want to file there and are covering the cost for it.
Yeah. And then just, I think more broadly, before we move on to a different subject, can you talk a little bit about what you view as kind of the pros and cons of these high, at a high level, these different strategies, kind of the sword versus the shield? I mean, I think the sword, I feel like, is probably a more expensive strategy, but could have some situations where it's, the right thing to do. Any comments on that? Like, what do you recommend for most companies in terms of a high-level strategy?
Yeah, so I guess one thing I would say initially is, in the beginning, when you're developing the product and you're filing your initial patent applications, don't worry too much about what that strategy is going to be. Like, we're going to try to enforce, and we're going to go after people, or, this is totally defensive. Just, being a startup, focus on having a good product that people want to buy, that fits in a market. Like, that's the thing you should be focused on. And when it comes to patents, it should be trying to protect as much as possible. You don't know what the situation is going to be years down the road when you get your patent issued. You don't know what competitors are going to be doing. You don't know what sort of strategy is really going to fit. I mean, you may want to think about it a bit, but a lot of times the focus should just be, let's cover as much as we can. Definitely try to cover our commercial embodiments. But for folks who actually do get to that point where they are thinking about, okay, what is my strategy? I have a more mature patent portfolio. So when you talk about like sort of the sword strategy, that's where we're going to be aggressive and we're going to sue people. We're going to try to stop people from getting into markets. It's pretty expensive. I would say baseline patent suit, it's going to run you at least $1 million. So you need a really solid war chest, and that's a really basic one. Especially when you get into healthcare products, you got to get experts involved, and it's long and time consuming. I mean, it's going to be multi-million dollar kind of stuff. So it's easy to say, yeah, we're going to go and we're going to sue people, but a lot of times people don't realize that's prohibitively expensive for most companies and doesn't really make any sense. A lot of times it makes more sense to be defensive, use the patents for marketing purposes, and you can really do all of those at the same time. It's not like you have to choose one strategy, like we're only defensive or we're only offensive. Totally depends on the competitors who come out. Totally depends on what the market is like. So I'd say be adaptable.
Yeah, I could see that. I think you touched on this briefly, but wanted to circle back to it. So if we were to take a hypothetical example, we start a company, you and I. When do we start thinking about our patent estate / IP estate, and what are the immediate steps we take to start get that ball rolling towards protecting that and building that estate?
Yeah, so the first thing I would say is you want to establish a relationship with a patent attorney early on. I think that's important, just to understand what is going to be patentable, what is going to be our patent strategy, but not necessarily with the goal of filing immediately. Part of that initial building of a relationship is to determine when should we time our patent filings. And there's really two things that are really going to be they're going to be driving that. One is America is a first to file system, so there's priority for whoever files first. So there's sort of a rush of like, okay, we want to file soon. At the same time, you don't want to file too early, because if you file an application that doesn't have enough detail, that isn't really fleshed out, sure, you get priority for that, but it's not going to help you a lot. So I say, wait until the product is more developed. But usually what ends up happening is companies end up filing before they start making public disclosures, public uses, or offers for sale, because that's when you start potentially losing patent rights. So I would say work on the product, get it up to speed, and file before you start making public disclosures, public uses, or offers for sale. That's usually the good timing of things. And yes, it's good to get an early priority date, but that's often outweighed sort of by the cost benefit. It's often better to wait until sort of later on, until the product is more developed. Also, kind of we talked about the provisional strategy where it gives you that year of flexibility. It gives you more, a later year of flexibility instead of having to, file something early and then, okay, now we figured out what we're actually doing, and then file again, and then file again. It's a lot more cost effective to wait and file that initial first patent application.
And just unpacking that a little bit more, in your experience, what is required? What would you recommend to put together a strong patent application?
Yeah. So,
in terms of like, how developed does the product have to be? How developed does the process or service that you're trying to patent? How developed does that have to be? Whether it's might be different based off of provisional versus non, but assuming we're taking your approach of doing a provisional for a startup, how developed do we have to be to kind of go down that road?
Yeah, so as far as the development goes, it doesn't really change whether it's provisional or non-provisional. Really, it's going to be the same things. And so what I would say, it really depends on the product. So I've drafted huge patent applications based on nothing more than scribbles on a cocktail napkin, right? People have a bare idea, and we can flesh it out and make it something substantial. You don't have to have a working prototype. You don't have to actually know what you're doing. You could say, well, it could be one of these 10 things that we're going to do. You could file a patent application on all of those things. That's totally fine. So as far as feeling like you're going to have like all these schematics and it's going to be all these you're going to have to draft all these documents for your patent attorney. Not necessarily. Any description that you have, any pictures of the product, any demos, things like that, that's anything that helps your patent attorney understand what the product is, that's all you're really going to need to do. That in combination with maybe a 1-hour meeting to do an invention disclosure, run through the process, how users interact with the product, talk about alternatives, what you're doing now, what you're looking to do, say, in a year, in 5 years, where it may be in 10 years if money was no object, and being able to cover all those things. But really, it shouldn't be a difficult thing. It shouldn't be an overwhelming thing. We're like, oh, we have to prepare all this stuff. A lot of times, we can work with the documents that are provided.
Mm-hmm. So if we fast forward, our startup is greatly successful. We've got a great patent estate, and things are great. Can you talk a little bit about the process of? I imagine there's a maintenance process of, keeping your patent estate current, up to date. What does that entail, and who's involved in that?
Yeah, so a lot of times it's actually, the examination process is still going to be going on. So as I mentioned, so you file the provisional application, you file the non-provisional a year from then. It can be a year to 3 years before examination even begins. And once an examination begins, it totally depends. I mean, it could be 6 months, but sometimes it could be 3-4 years before examination ends and you have an issued patent. From there, like I said, you can split it off, you can do continuations, then that process continues. So a lot of times within Life Startup, they're still working through the examination process. So that tends to be the main thing. But during that, you want to be thinking, okay, where is our product compared to what we filed on initially? And do the claims actually cover what we're doing now? What competitors are in the market? Do the claims, did they potentially cover the competitors? Should we try to shift things in this application to what competitors are doing? Or maybe do we want to do a continuation to cover what they're doing? Those tend to be the big maintenance things that occur early on. It's not as much, you have a bunch of issued patents, because then they're issued, you pay maintenance fees, and then it's pretty simple. But yeah, a lot of times it's making sure that your portfolio, it's covering the things you want it to cover, and that you don't need to file new applications on new things that you're doing.
Got it. Okay, that's helpful. And knowing we've only got a couple minutes left here before opening to Q&A, just wanted to ask you, maybe just for one example, a real-life example of a company that you think did a great job of building and maintaining its patent/IP estate, and then maybe some or one example or a few that show companies that didn't necessarily do a great job of doing that.
Yeah, so I can give an example. I work with a group of companies down in San Francisco. They do a lot of robotics, and they've been really successful in kind of the strategy that I've been talking about, where we filed provisional applications and we did them relatively inexpensively, but we did them in a way where they were high quality, had a lot of detail, had a lot of different options, and filed updated applications along the way. So with one company, they do robotics in the space of, so it's like solar arrays and doing actuators for solar arrays. And their product has changed a lot. They started out, they had an initial idea, they pivoted to another, and then they actually ended up going back to the original idea. Because we did a good job and we had all the different variations in there, we've been able to adapt the patent portfolio to cover what they're currently doing and then cover the future generation. So, and then a lot of investors have been interested in them because they have a strong patent portfolio, and there's a lot of ability to cover white space, as in things that are not currently covered in the solar actuator field, and there's broad protection so that when competitors do come in the market, we can go after them as well. That would be an example of doing it well. I wouldn't want to name names with folks who haven't done well, and this is people who've kind of come to me too late a lot of times. And the big example is folks who've over-invested in foreign patent applications. This company I worked with a bit, they filed a single US patent application and filed in 20 different foreign countries. And to give you a general sense, when I give people estimates, I say, assume it's going to be $25,000 over time for each jurisdiction that is English speaking, $35,000 per jurisdiction for non-English speaking countries, because there's a lot of maintenance fees. I mean, a lot of it's government fees. And the way it works is you have to have a US patent attorney, and then you have to have an attorney in foreign jurisdictions, so you can see how it ends up being expensive really fast. They dumped, I don't know, several $100,000s into this, big foreign portfolio, and then realized, oh wait, we're totally going to do something else. We're going to have a different product. This doesn't cover any of it, and they'd wasted tons of money on it. Yeah, wow. And it was one of those things, and that's it's a good example why I tell folks, like, do not overinvest in foreign protection, because they're like, we're going to take over the world, and this is going to be everywhere. Everybody in every jurisdiction is going to need this, and I mean that's that's great to think, but as far as getting protection everywhere, it's not a great idea.
Yeah, no, that's not a good idea. Well, 15 minutes for Q&A. Dylan, that was great, by the way. Thanks for coming in.
Yeah, thanks for having me. Appreciate it.
If I didn't ask a question that you guys have, feel free. I also have a few more if necessary, but wanted to give people a chance to get their patent questions answered.
Hi, great stuff. Question on the offensive versus defensive idea, where if you have the patent, but you're not proactively protecting it, so going after those that might be infringing on it, is there a possibility of potentially losing that patent because you're not doing it if a competitor had been using it that maybe you weren't aware of, or so and so? Yeah,
that's a great question. So for trademarks, that is true. You actually have to enforce trademarks, otherwise you potentially lose them. That's not the case for patents. So you have typically it's going to be 20 years from the filing date of the non-provisional application. Unless you do something affirmatively to tell these people, hey, it's okay, go ahead with what you're doing, you can enforce it at any time. There's no need to affirmatively enforce things. And honestly, a lot of times when it comes to an offensive strategy, I tell people, wait, let the damages accrue, right? That can be a positive thing, unless it's an issue of you need to get somebody out of the market or there's other strategic reasons. It's fine to wait and to enforce things, and that can a lot of times be a better strategy. Yeah, because there'll be more damages, and then it'll be a case that'll actually be worthwhile.
Hi, Dylan. Excellent talk and excellent introduction to patenting.
Yeah, thank you.
So Just a question, as you were talking about software patents. So unlike the biotech or the pharmaceutical industry where you can patent around certain entities and you can protect that more aggressively, in software it tends to be a little bit more loose. And so, Uber came in first. I'm sure they had a lot of patents. Lyft comes right after, takes away a lot of the market share. Doesn't stop Lyft from doing its business. Slack, and then Microsoft enters that space. A bigger gorilla enters the market and takes it away from you. And so what's the value of patenting in these areas if you can't prevent your competitor from coming in? And is there any additional benefits of patenting?
Yeah, good question. So as far as, so a lot of times, it's going to be difficult to stop somebody from having a business that is going to be exactly like yours. So kind of like we were saying earlier, you can't necessarily protect the business model, but you can protect certain features of that business. So there are going to be a lot of features that Uber can only have that they're not going to, that Lyft is not going to be able to have. And those are going to be there's going to be functionalities of the app. It could be the way data is processed. It could be certain algorithms. So it's not going to be the overall business, right? And that's pretty typical with a lot of companies. There are going to be competitors out there, but there are going to be certain features that you may be able to have that are going to be proprietary to your company that you're going to be able to exclude others. And assuming that those are important functionalities, there is going to be exclusivity there. Does that answer your question? Is that helpful? Nice.
So one of the things that I think we touched on was just around cost, which I hadn't really appreciated, kind of what the actual cost was of building a patent or IP estate. Can you talk a little bit about, I think you talked about some strategies to help optimize, and I think one was kind of the provisional idea, but any other, again, going back to the lever analogy, what other levers can we pull to help really optimize our patent spend to get the most out of what we have allocated for kind of building that patent IP estate?
Yeah, so I think a lot of the value is, well, I mean, part of what drives the cost of patent applications is going to be the complexity of the technology, and it's going to be the amount of, the number of variations that you want to cover. So definitely at the non-provisional stage, it needs to be something that's attorney drafted. You're going to end up with, I mean, honestly, worthless, a worthless patent application and worthless issued patent if it does issue, if you do it yourself. So a lot of times it's going to be, you can scale the amount of variations that you have. That can help reduce the cost. But a lot of times, you want to maximize that. I think one of the things that can be useful is, well, instead of trying to throw all these variations into one patent application, which is totally fine, you can do that, split it into two so that, if you do have to spend more money for one application because it's really complex, get 2 patent applications, get 3 patent applications out of it, right? So that at least the optics outwardly is, hey, we have a portfolio that has 5 applications instead of one huge omnibus awesome patent application, because people don't really see it as, wait, we have this one great one. They see it as a numbers thing. And so that's a lever that we typically pull. We, instead of having this one big omnibus thing, we'll split applications into multiple so that, it has at least more perceived value.
Yeah. And then just another broad market question. I mean, I've seen some very high profile patent deals done, right? Where you see Microsoft, for example, buy 1,000 patents for X number of dollars. And I've never really understood, maybe you can help me understand this, how they ultimately get to that value for these deals of these bulk kind of patents. How does that work?
Yeah, so I guess I'll kind of use an analogy. So, when you talk about intellectual property, using property as an analogy is really good. So you got to think about, let's say you're buying a piece of property, and somebody says, hey, how much is this piece of property worth? Well, what are the 2 main things you're going to ask? One is, where is it, right? Is it in the middle of nowhere in Arizona? Or is it like right downtown in Manhattan? And then what size is it? If you have an acre of land in downtown Manhattan, that's worth a lot of money. Or if you have 100 acres in the middle of nowhere in Arizona, that's not going to be worth as much. So the analogy there is, So if it's in a really hot tech space, right, even if you have a small little sliver, it could be really, really valuable, right? On the other hand, if you have a huge, huge patent portfolio, but it's in a space that, it's a small market, it's not as attractive, you know, there's not a lot of competitors there, just, you know, the amount that people pay for the products is really low. That kind of that kind of portfolio is going to be less. As far as like how they come to the numbers, I mean, there's a lot that goes into patent valuation, but that's kind of the big thing to think about is, you know, when you're investing, you know, think of it like buying real estate. You know, like, am I buying, you know, like, I always think that there was an example where somebody bought it was like literally a parking spot in London for like, I think it was like $800,000 or something, right? You know, so, you know, if you have that really key piece of IP, and if it's in the right tech space, that can be absurdly valuable. So it doesn't need to be something massive and groundbreaking. And a lot of times that's where the big patents aren't. It's not, you know, to these broad things. And kind of like you could go to your example of, you know, Uber versus Lyft. It's not protecting the whole, you know, the whole company and the business model. It's protecting these small features. And where there are these key features, there can be huge, huge value.
Yeah, go ahead.
Can you give me advice about, like, when you think about this, there is an idea or an IP that to be protected. How do we go about thinking about who to hire and how to hire somebody to help us think?
Yeah, so as far as like, you know, I would kind of reiterate, you know, talk to a patent attorney early. A lot of times, most folks are going to give you at least a free hour consultation and kind of give you a general sense of, okay, well, you know, where are you at with your product? When should we try to file patent applications? What is the general cost going to be? What is the general strategy? But as far as picking folks, I would say the biggest thing is find somebody who has a technical background that matches your product, right? So at every patent attorney, like, we have to take a special bar. We have to pass what's called the patent bar in addition to, you know, being a state attorney in certain states. One of the requirements is you have to have a technical background, right? So make sure that it's somebody who has a technical background that fits your technology and at least maybe has some experience with that. A lot of times it can be difficult. You know, you want to find the expert in whatever your product is, but if they're the expert, it means they already represent a bunch of clients in that space, so they may not be able to represent you. So there's kind of that balance, right? So if you have a software product, make sure that you're talking to a patent attorney who is probably electrical engineer background, computer science background, and their focus is at least a large portion doing software patents. But kind of more than that is, you know, for a patent attorney, that should be their primary thing. They shouldn't be, well, I'm a litigator, and I'm a patent attorney, and I do contracts, and I do licensing. The best patent attorneys are people, you know, who do 95% patents. That's the person you want to find. You don't want to find the jack of all trades. Like, oh, I could file a patent for you, or, you know, that's not going to be very good. Patents are very specialized. Patent attorneys are very specialized as well. And to confirm that they are a patent attorney, you can go to the USPTO, put in their name, and make sure that they have a registration number. Make sure that they are actually a patent attorney or you know, a registered practitioner, because otherwise they're actually not able to represent people before the USPTO. And I've dealt with that too, where people have come in and say, hey, you know, my business attorney filed these patents, but one, they totally screwed it up, and they weren't really able to do that, right? They probably were well-meaning, they wanted to help out, but you know, they were not, you know, actually licensed to do that, and you know, as a result, kind of messed people's stuff up.
I have a question for Kurt. Listening to Dylan talk about how companies can buy patents, many patents, a patent from another company, I would imagine that it's a startup. It could be a startup strategy just to come up with an idea, get a patent, and sell it, and that's their whole business. But also, Dylan said that it's important to create a patent when you're ready in the development process. Make sure that it's good. So then that slows down that time. What is valuable from a VC perspective? What is the most valuable for a company, to have many patents or to have one good one?
It's a great question, Jessica. I mean, I think the answer is it depends. Like, like the answer to most hard questions. I think like Dylan said, and some of the things I'm taking away from our talk is quality is king, if that makes sense. And I've thought a lot about this. I've seen some companies that come and the first thing on their slide deck is look at our patent portfolio. And actually, to me, that is a bit of a turn off because it doesn't actually link kind of the business and company strategy to what they built, right? And so I think that's what I normally look for is a well-defined business and company strategy in which the entrepreneur management team has built their patent portfolio in a way to not necessarily go on the offensive, but to certainly protect the intellectual property that they've created in essentially creating the company. So I think it's the right mixture of truly showing your product market fit, if you will, and protecting that with your patent portfolio, not the other way around.
Yeah, I would agree with that. I mean, not being a VC, but in my experience with companies is if they go in and like our whole business model is all about patents and that's their focus, that's going to be a huge turnoff. And like you said, it's like, well, but you're not thinking about your product and about your markets. You're just building this huge, expensive patent portfolio, and then what do I do with that? Like I'm investing in a business, not in a patent portfolio. That's a whole different, business model, right? So there has to be the synergy between the patent portfolio and the business, and they have to work lockstep. And I think that may kind of come in with what you're saying. And one thing that we talked about previously was you don't need to have a developed patent portfolio. It doesn't need you need to have issued patents. A lot of times it's just important to have a strategy and be able to articulate that. Say, hey, we haven't filed patent applications yet, but we are doing so strategically. We are waiting because we want to have more flexibility, and we're going to wait and file before we make public disclosures. Here's what we're planning on filing on. It doesn't necessarily need to be some big developed thing and have all these patents yet. It depends on where you are in your in your company.
I would say as equally a turnoff as the case I put forth, which is leading with your patent portfolio, is when you ask the question, so what's your patent IP strategy? It says, what are you talking about? Right? That's also that also shows that they aren't thinking about the right things. So it's that balance of making sure that it's aligned with their patent IP strategy is aligned with the business and the work they're doing there. So.
And that's pretty easy to check that box. I mean, like I said, a lot of attorneys will give you an hour consultation. You could probably get that information in that hour free consultation and be able to use that. Like that's, it's not like it's going to be expensive to get that information. Even if you're at the early stages and it's going to be years before you actually file, it's good to have that in mind. You can say, hey, here's our plan. We've talked to a patent attorney.
Yeah. So the question would be how. Thanks. I probably should have ran to you. I'm sorry about that. So the question would be how then. Now, granted, Davis, Wright, and Tremaine, I'm sure, fantastic. But how do we search for somebody that may be specific on a product that we're looking at developing?
Yeah. So I think the first thing is try to get recommendations. You're going to find better folks by asking your network. I mean, otherwise, using searches like, say, AVO, those can be the other ways of doing it. You could, I don't know. I think talking to your network is the best thing to do because as much as you could work with a patent attorney, really, anywhere in the country, it can be helpful to work with folks who are local, so you can actually sit down with somebody. They can, come and look at your product and talk to you. So I don't know. It's sadly it's kind of hard to find good patent attorneys. Like, people ask me this all the time, and like, I don't know. There's not a good service, or there's not a good search engine. I mean, AVO's the first one that comes to mind. Even that one's not great. But definitely, like a lot of folks, interview a few people, talk to different folks and see if it's a good fit. But yeah, I think the biggest thing is make sure they have the right technology background. Their focus is on drafting patent applications and working them through the USPTO. Those are the things, I think, the threshold questions you'd want to ask.
One follow-up on that to you, Dylan, is
can you be a good patent attorney on everything? Or are you, like if we had a hardware product, would we be searching out someone that has done lots of work in the hardware space? Would we be searching for someone that's done lots of work in the software space? Within that, let's say we're doing healthcare tech. Would we need to search for someone in particular that has experience in that space, or would we be okay with a software generalist, if you will? Because I'm trying to get a sense for how specialized do patent attorneys become? And if so, what's your specialty?
Yeah, so I would say, so first there's going to be two main specialties. One is going to be folks who focus on computer stuff, and then there's going to be people who do biotech. So for instance, like for me, you know, yeah, I have an undergrad in biochemistry and molecular biology. I've done a bit of biotech, but if somebody comes to me and says, hey, you know, I have this biotech patent that I want to do, I'd be able to understand it, but I am not the person to do it. So for me, my focus is going to be on computer hardware and software, and mechanical devices, like, you know, so Amazon is one of our big clients. We do a lot of AWS work. But I work with individual inventors, like garage inventors, folks who've been on Shark Tank, startups. I do a lot of robotics. But as far as sort of specialties within the computer space, if you're doing really specialized hardware, then yeah, you would want to find somebody who's specialized in hardware. But software tends to be, anybody can do software regardless of what the space it's in. You know, whether it's in the healthcare space or it's e-commerce or whatever, software is going to be software. But you know, maybe if there are special, you know, special things like, you know, if it's, you know, like large networking, like Amazon, you know, somebody who knows about virtual computing and large systems like that. But on the same side, you know, if you have a small, like a, you know, an app-based application, make sure somebody has done some app-based software stuff and they kind of know the specifics with that. Or if it's device stuff, make sure that they've done some device things so they understand how, you know, well, hey, you know, sensors play into this, and it's, you know, there are some subspecialties. But by and large, I would say, you know, it's in the computer space, if you're doing specialized hardware, try to find folks who've done that, but otherwise, just general software is fine.
Any last questions? Yeah.
You kind of touched on it beforehand, but I was just curious that with the evolving space with AI and machine learning and cloud services, you know, how do you see patent strategy or filing applications and patents evolving with that technology as it's rapidly growing so much?
Yeah, so you know, in a lot of ways, it's kind of the Wild West. It's pretty new as far as AI goes. AI is going to be protectable in two ways. One is going to be the functionalities that are achieved through AI, and one is going to be the actual AI itself. I think it's going to be important. I think we are yet to see, you know, the AI that's really going to dominate the market, and like that's why I'm excited to work with AI companies, because, you know, I would love to be part of that company who really builds the portfolio around some core AI that, you know, in some ways, you know, it may be 5-10 years out before we really have that core product that's like the Microsoft Windows of AI. But, you know, we'll definitely get there. It's a cool space.
Well, thank you, Dylan. Thank you, Kurt. That was really interesting.
Thanks, everybody.
Yep, thanks.